Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh, give their attention to the court, now sitting.
Thank you. Please be seated. Good morning. Welcome to the Supreme Court of Kansas. We look forward to an interesting discussion with counsel on the issues contained in their briefs on this morning's docket. With that, I will ask the Clerk of the Appellate Courts, Ms. Carol Green, to do the honor of calling this morning's docket.
May it please the Court, Dan Monnett, appearing for Mike Akins.
The State appears by Assistant Solicitor General Natalie Chalmers.
Number 102,814, State of Kansas versus Owen.
Carol Carver Ullman, Capital Appellate Defender, on behalf of Ms. Owen, present and ready for argument.
May it please the Court, Assistant District Attorney Boyd Isherwood on behalf of the State of Kansas, present and ready for argument.
Bill number 104,083, State of Kansas versus Foster, on petition for review, Shawnee County, briefs both sides.
May it please the Court, Heather Sussman with the Appellate Defender Office here on behalf of Mr. Foster, President.
May it please the Court, Jason E. Geyer, Assistant District Attorney on behalf of the State, ready for argument.
Bill number 102,749, State of Kansas versus Powell, on petition for review, Greenwood County, briefs both sides.
Please the Court, Corey Call, representing Ryan Powell, present ready for argument.
May it please the Court, Joe Lee, representing Greenwood County, ready for argument.
Appeal number 109,712, in the matter of Michael Clay Schnickler, an original action, and no briefs in this matter.
May it please the Court, Alexander M. Walzak, Deputy Disciplinary Administrator, ready for argument.
May it please the Court, the respondent appears in person by John Ambrosio. We are ready for argument.
And that concludes the docket.
Thank you, Ms. Green. Now turn our attention to the first case on this morning's docket. That is case number 105809, State of Kansas v. Michael Akins, Jr.
May it please the Court, my name is Dan Monnett. I represent the appellant in this case, Mike Akins. I would respectfully request the reservation of 3 minutes rebuttal time, please.
3 minutes is granted.
Thank you, Your Honor. During the breakup of Chief of Police Mike Akins' marriage, he was accused for the first time of molestation by his stepchildren. Did he get a fair trial, before which he received 2 consecutive life sentences plus 59 months, or were his convictions fatally flawed by prosecutorial misconduct and the erroneous exclusion of relevant evidence essential to his theory of defense? Although we raise several issues in our brief for purposes of the discussion this morning without abandoning any, I'll restrict my comments to those 2 issues: prosecutorial misconduct and the exclusion of evidence that M had previously falsely accused her biological stepfather of child abuse. Prosecution misconduct here denied Mike Akins a fair trial by the prosecutor, in effect, testifying as to grooming and testifying as to finding words constituting the gold standard of child interviewing, and by the prosecution's misstatement of law that the intent, the sexual intent, comes from the grooming, and it occurred throughout the case. The prosecutor bookended this case with, in effect, her own unsworn testimony about grooming. During opening statement, the prosecutor referred to actions of Mr. Akins as grooming his stepchildren for later sexual exploitation, and she concluded opening statement by saying, at the end of this case, I'll ask you to return guilty verdicts based on his power, his control, his access, his grooming. In closing argument, she returned to the theme, stating that the sexual intent comes from his grooming and suggested the grooming was a process of desensitizing the children. Why was the prosecutor's unsworn testimony about grooming misconduct? Foremost, because she repeatedly stated facts not in evidence, namely the general proposition that grooming is somehow connected with child molestation, and the specific premise that here actions occurred which in effect constituted grooming. Certainly no expert testified as to the existence of this pseudoscientific concept, and the prosecutor knew as early as the pretrial motions that she never intended to introduce any expert testimony. True, here the prosecutor did not, like the prosecutors in Simmons and Champasing, elicit non-expert statements from prospective jurors about the psychological concept. But here, the prosecutor just employed a different tactic. The prosecutor here relied on whatever non-scientific, unspoken concept of grooming the jurors had derived from the media or the street, and then this prosecutor diagnosed specific actions of the defendant as constituting grooming. If admissible at all, some kind of expert testimony was required to explain this to the jury. That's clearly the suggestion of the Kansas Court of Appeals in the Machaney case, where they point out that particularly in the context of a parental or step-parent relationship where affectionate and playful behavior can be expected to occur, some elucidation of grooming, distinguishing it from what every parent or step-parent does, is necessary. And I believe that the necessity of expert testimony on the general and the particular proposition are implicit in Justice Lupert's opinion in the Rasky decision, when the court distinguishes the prosecutor's activities there, saying, quote, "The prosecutor did not attempt to step into the role of psychologist by connecting the acts of purchasing and gifting the objects to the concept of grooming." Here, the prosecutor did step into the role of a psychologist. She did diagnose particular actions of Mr. Akins as constituting grooming in the same manner as the prosecutor in Champasang and Simmons relied on the non-evidentiary, non-testimony of jurors from which to show specific acts were grooming. This tactic, I know Justice Breyer denominated really as a kind of cynical manipulation towards a pseudo-scientific conclusion in Champasang, and this is the same tactic, they just don't elicit the general proposition from jurors in the beginning. And this kind of testimony by a prosecutor, a highly regarded, experienced prosecutor, can sometimes be dynamite. The case here was bookended with this testimony about grooming. When a prosecutor argues facts that are not in evidence, usually this court, as was recognized in Simmons, finds that the first prong of the prosecutorial misconduct test of Tosh has been fulfilled. It remains to be seen, did it constitute plain error here? There are three aspects to that test.
Mr. Monnet?
Yes.
What if the prosecutor had not used the word grooming, but had just talked about these, you're going to hear proof of acts that are kind of building toward certain behaviors or something like that? If, in other words, just didn't use that particular word, would that...
Then I think the case would be more like Rasky, where the prosecutor never used the term grooming, but it was sort of implicit in the argument, because she does use this pseudo-scientific term that the jurors may well have negative connotations about from the media and the street. This case, then, is more like the Stockholm Syndrome argument in Simmons or the piecemeal disclosure referenced in Champasing. If she had not used a pseudo-scientific term, it would be a better case for the prosecution. But
Was grooming ever talked about in terms of the term during jury selection?
not that I've been able to find, Your Honor. So it is different in that sense, and here there's just no evidentiary support.
It was opening statement and closing argument here, right?
True.
Although she built on stories or reports that the jurors had made about their childhood or their own knowledge of disclosure or...
I don't remember her eliciting that in this case. That kind of thing was elicited in the other cases.
Other cases, okay.
Here, there's not even the fraction of juror testimony to support the general proposition. The prosecutor just relies on what the jurors may know.
You can argue, though, that the behavior during voir dire is more damaging because you have the endorsement of someone who's going to be a fellow of others on the jury. I mean, in some ways, that's even worse than the prosecutor saying something in opening and closing. You understand what I'm saying?
I do. But either way, Justice Breyer, I think the flaw here is that it amounts to statements about things that have not been introduced in evidence at all. If the jurors testify about it, it's not evidence. If the prosecutor doesn't put on any evidence to support the general concept, it's not evidence.
I'm sorry. Did you object as any of the evidence was coming in, and I recognize it wasn't coming in as grooming evidence as such and no expert testimony, but since the prosecutor did refer to grooming in opening arguments, and then we have all these kids testifying about these acts that she then follows up in closing and says, these are the acts, this is the grooming, this shows the intent. Was there any objection anywhere to the relevance of their testimony, or did you assume this was going to be tied up somehow with some expert testimony?
I apologize that I was not the trial attorney,
right,
but the trial attorney did not object, but no objection is required here.
I understand to the prosecutorial misconduct, but I just wondered, since you're suggesting, it may have been objectionable as grooming evidence, I take it there was no objection because it seemed to be relevant to show, some sort of pattern of conduct building up towards the acts he was charged with. I mean, there was no relevance objection.
There was, regrettably, no relevance objection. And had the prosecutor been going to introduce evidence about this and let us know or let the defense know ahead of time, then perhaps some motion in limine could have been filed to exclude this questionable scientific evidence about grooming. I want to point out that in considering whether this was conduct that was gross and flagrant or ill will, that this isn't the only instance of prosecutorial misconduct that occurred here. After the prosecutor introduced the concept of grooming, in closing argument, she explained to the jurors the sexual intent comes from the grooming. Now, exactly what that might mean is a little confusing, but certainly one juror might understand that means that if the jury, for instance, had a question about whether a particular touching was done with the specific intent to arouse or satisfy the sexual desires of the offender or the child, that juror could look back to evidence of grooming, such as the child assisting in shaving Mr. Aiken's back, to supply the intent on the act the jury questioned. The problem with that is, as the Court of Appeals recognized in Boone, usually you have to, for aggravated indecent liberties, have to have a union of lewd touching and sexual intent. So it was a misstatement of the law. It was a misstatement of the law that denied the prosecutor, that denied Mr. Aikens the due process due him.
Why is it still not circumstantial evidence that there was that joining of intent and lewd touching at that point in time? We often look at prior behaviors to allow inferences of intent.
It could be circumstantial evidence of the intent that he had at the time of the action, but that isn't what the prosecutor said. She said the sexual intent can be supplied, in essence, by the grooming. The other instance of prosecutorial misconduct that occurred in this case, and this probably lets the court know something about the ill will and grossness and flagrancy of the misconduct. Picture this. The defense expert, Dr. Kathy Nickel, has testified about some problems with the finding words interviewing technique used to interview the children. On cross-examination, the prosecutor asks Dr. Nichols, were you aware that finding words has been called the gold standard? The defense objects. The prosecutor has testified. The objection is overruled. The witness answers, I am not aware that someone called it that. Now, standing in the courtroom, with the full respect the jury accords to the office of the Attorney General, the prosecutor just simply states the case is Mooneyham versus State. Thank you very much. What could be more flagrant misconduct than the prosecutor thinking she can impeach the defense witness by her own unsworn testimony from the pit of the courtroom? Every prosecutor knows that you can't do that, and that shenanigan, I think, tells you something about the rest of the misconduct in the case, and I hope it resolves any doubts of the court about whether this prosecutor was trying to broadcast loud and clear throughout the trial, I am the only child expert in this courtroom on grooming, interviewing techniques, the credibility of witnesses, and the intent. I also want to point out that there was error in this case when the court excluded from evidence.
Before you get to that,
yes, sir.
Would you speak to the citation to the case? The prosecutor said the case is and gave the name. Did that case support her statement?
The only use of the term gold standard is in a concurrence of Mooneyham, and I can't remember now whether it's from Vermont or New Hampshire.
It's not a Kansas case.
Yeah, not a Kansas case. And it certainly was an instance of a prosecutor trying to cite a case to the court. It was the prosecutor trying to impeach the defense witness with her own testimony.
But my recollection is that even that concurring opinion, when it used the term gold standard, it was relating what had been said or referred to by someone else. It wasn't a declaration that that method is the gold standard, was it?
No, that's exactly right, Your Honor. It wasn't central to the hearing in any way. It actually was quoting some other case or some other authority. On the issue of the...
Counsel, I want to continue on this because as I read the state's brief on this particular point, the misstatement about the gold standard that's volunteered is that other than trying to get around this by saying that defense counsel at trial didn't object to the statement, take that off the table for a second. Other than that, the state does not argue that it wasn't gross and flagrant or ill will or a misstatement. All the things you said in your brief, the state didn't address those. So let's assume those are waived. Talk about harmless error because that's where they'll be next. On this process, just take the prosecutorial misconduct, wrap it up, and let's talk about whether this is harmless or not using the Chapman standard and from our cases in Ward, where the state now has the burden to show beyond a reasonable doubt that it was harmless.
Yes, Your Honor. On any of the acts of prosecutorial misconduct, the state will never be able to bear its burden of showing this was harmless beyond a reasonable doubt. For one thing, none of these stepchildren ever made any complaint about molestation until after there was an argument between their parents and the stepchildren left home with the mother. M kept a diary over all of this period of time that her mother was married to Mike Akins. She often complained in that diary about the actions of Mike Akins, but she never mentioned anything about sexual touchings that she claimed had been going on for a long time during the marriage of the two.
And the diary was in evidence?
It was, Your Honor. As well, there were mixed verdicts returned in this case. Some guilty, some not guilty. There was room here from which a jury could have found Mike Akins not guilty, but for the prosecutorial misconduct that occurred here. This can never be demonstrated to be harmless error. I see I'm out of time. I'm happy to continue. If I may, I'll come back to the issue on the wrongful exclusion of evidence relevant to the defendant's theory of defense in my 3 minutes of rebuttal.
Before you sit down, counsel, you elaborate on your contention about mixed verdicts supporting the claim that the error is reversible?
Yes, this case was not easy for the jury to decide. The jury was out for 2 days. They deliberated long into a Friday night, and they did not return across-the-board guilty verdicts. There were some lesser-included verdicts. There were some not guilty verdicts. I think it wasn't an easy, and at one point they asked for a readback on what evidence, what they asked for was a readback of the prosecutor's closing argument where she tried to link particular acts to particular counts in the information. In other words, it was a case the jury struggled with, and as such, this prosecutorial misconduct can never be deemed harmless error because but for it, the jury may have returned not guilty verdicts.
Can you help me with the specific numbers if your memory is good? How many different charges went to the jury? How many were there convictions on the main charge? How many were acquitted? And how many were lesser-included offense convictions? Do you have that at your fingertips?
Here's what I think it is, but I rely on our brief for perfection. 19 counts went to the jury. 4 counts were not guilty, and 2 counts were verdicts on lesser-included offenses, I believe.
All right, thank you, counsel. Any further?
Yes, sir.
And all of the not guilty related to the sole male child.
They did, Your Honor. Thank you very much.
Any other questions of counsel? All right, thank you.
Thank you.
The state appears by Assistant Solicitor General Natalie Chalmers.
First question, Chalmers, do you agree with that count that your opposing counsel just...
I'm not sure what the total number of counts were, but I know I agree with the 4 that were acquitted were in regards to the boy child E, and the 2 lessers were both to, I believe, M's testimony at trial.
Okay.
And it was due to the fact at trial she didn't testify. I have this in my brief somewhere. I was trying to look for it. She testified that there was not penetration at trial, so they found the lesser count that there was no penetration.
Thank you.
First, as to the grooming, I'm going to address the misconduct, and I also hope to address the exclusion of the alleged false accusations. As to the grooming, the prosecutor here didn't try and make any argument in either opening or closing or at any time throughout the trial that there is some kind of psychology behind sex offenders and grooming. She used the word grooming, I guess, as he had said, building up would have been okay. She used it as to mean building up. Basically, it was a label. This court has previously discouraged wordsmithing and say that the use grooming was used in a typical fashion in the way most normal people would use the word grooming. Thus, I think it was
brushing their hair.
What?
It didn't mean brushing their hair.
I did not mean brushing your hair. That's true.
It was used in a specific context in sex crimes.
It was used in a specific context, but you could also groom people for offices. You can groom people to do many things that are not sex conduct. While she did use it in this case as grooming for sex conduct, it doesn't mean that the word grooming was somehow a psychological expert evidence that should have had expert testimony.
Do you think it has a negative connotation in this context?
Yes. I mean, she definitely was using it.
And is that appropriate? Is it pejorative to use the word grooming as opposed to some other description of building up or desensitizing? Or
well, I don't know
what
that
would your
desensitizing
response
would have been any more approved if that, I mean,
It was used to mean desensitizing.
it was used to mean desensitizing, absolutely. So I'm not sure that, if the thing is, you're not allowed to say that a victim, I mean, I guess I'm confused by the fact that it seems like we should be able to say grooming is the quickest word that she thought of. Grooming is probably easier for many jurors to understand than desensitizing. I don't know if it would have been okay if she had said desensitizing rather than grooming. I don't know
I'm
that
not
negative.
absolutely certain I understand what the prosecutor was getting at about grooming. I have a sense, but when you say it's the quickest way to get to the understanding, I think it's the quickest way to confuse the issue, isn't it? Do you have a precise definition of what grooming means?
No.
And can you explain to me what the prosecutor meant when she said that the sexual intent comes from the grooming?
First, that's an incomplete quote. That she goes on to talk about other circumstantial evidence in that particular. She doesn't just end it. That's not the end of the sentence there.
Even if we assume that, Ms. Chalmers, can you answer Justice Johnson's question?
Yes. When she says sexual intent comes from grooming, I do think she means, as she goes on to finish the rest of the sentence, it comes from all the actions, but the fact that he is basically training these young children to accept sexual advances is the way she's using it.
But there was no testimony to support that concept.
Well, there was evidence that it did build up, that there was this touching in one place, and then it continued to advance. That supports that particular...
It supports that the acts occurred.
Yes.
It doesn't necessarily support the conclusion drawn from them, right?
It's a reasonable inference from the acts that occurred.
There's a difference between a reasonable inference from facts leading to another fact, as opposed to a reasonable inference from facts leading to a conclusion about someone's mental state or some psychological concept, which is what the grooming is. That these are behaviors in which a sex offender engages in order to desensitize children so that he or she can perpetrate a more serious offense. Isn't that right? That's what it's used for. You acknowledged earlier that it's kind of a term of art for sex offenses. Grooming is a term of art.
Yes.
Yeah, and my colleagues pointed out that it really, with a lay jury, it may confuse them more than enlighten them, because they're not steeped in all of this like you are, or I am, or other people who hear about it all the time, right?
Right. And to that extent, if it is confusing to the jury, I don't see how they can then say, well, this is a the equivalent of a diagnosis with psychologists. So if it is confusing to the jury to any extent, I don't see how that becomes harmful to the jury then.
Well, the harmful part that I see is that you're telling the jury as a matter of law that the sexual intent can come from the grooming, not be inferred from but come from the grooming. And the danger is that when they look at the elements of instruction and it has an intent requirement, a specific intent, and they've been told, well, that element, you can just go back and agree that there's been grooming and that element's met. That's the danger.
I see what your point is, but she never said that it could only solely be from the grooming. She went to talk about all the other circumstantial evidence. Right. So to me, basically what she was saying, maybe it should have been worded more artfully, was that these circumstantial evidence show the intent when he later sexually touched these children. Or at the time he sexually touched these children. As to counsel's argument that the confusion of the jury, the 2 hours they spend, the mixed verdicts actually shows that misconduct affected the jury, I would say it goes the other way. the fact that the jury didn't immediately say, oh, check yes to all the guilty verdicts, that's what I would expect if the misconduct affected the jury.
Counsel, do you accept my characterization of your brief that you, on the gold standard and counsel volunteering the name of a case to claim credibility for what she had said about the gold standard, which in fact doesn't say what she said, shows ill will, gross and flagrant, and, well, quite honestly, I'd characterize it as appalling. By an assistant attorney general to do that in a trial, I think is appalling. So let's make the harmless error argument from that perspective.
I'd say that
I think your case is hanging by a thread because of prosecutorial misconduct. And that's a tragedy.
I agree that it's a tragedy. As to that comment, it was made. It should never have been made.
It was gross and flagrant. You haven't argued otherwise, so that's off the table. We just have to agree with it.
Okay.
And once we've agreed with it, doesn't it contaminate the other
I don't think it
prosecutorial
does.
misconduct?
I mean, there was a battle of experts here about whether the interviews were appropriate. That particular statement wasn't emphasized. She never said it again. It was one statement in a very long trial. I don't think that one statement would have had such credence with the jury that it would have caused them to believe the victims rather than the defendant in this case. I don't think that statement had any.
That's my colleague's question. He's
I'm sorry.
asking you to consider it in light of the other allegations of misconduct. He's asking if you look at the whole trial, including the other allegations of misconduct.
Oh, I thought he was just asking as to that particular one.
Oh, I think you have to think that this infects all the other allegations. But let's get to harmless error on this one.
Just on this one, or
on the whole, on
all of
prosecutorial
them?
misconduct. Let's just assume we got a problem here.
Okay.
Make the argument that I think you do make in your brief, which is even if we assume all these things,
right,
or we concede all these things, we still, with our burden, do not have error. So just make me the case. If
Okay, I think part of that is the jury did carefully consider the evidence. They took 2 days to do so. They didn't just automatically convict. They did not convict of any of the counts with E. They stuck with her trial testimony. It's clear the jury believed that the victims were credible in this case. And I don't think that any statement made by the prosecutor pushed them one way or the other. It was the evidence itself, the credibility of those victims, the believability of their accounts, how they corroborated each other, especially with the little girls that were forced to shower with each other. All of that evidence is the reason this man was convicted, not anything the prosecutor said. That may have been misconduct. As to...
That's certainly your opinion. Do you have any cases to point us to where there would be similar types of behaviors by a prosecutor?
I am not aware of anything like the golden standard
citing a case that nobody knows about. Okay, how about the grooming? Anything other than the cases that have been cited to us that your opponent mentioned?
Right. The cases that he mentioned were all done in voir dire, or however you're supposed to say
There's
that.
A distinction.
And that didn't happen here. Here there was, like in Rasky, there was no objection to any of the, they knew in opening that she was going to use grooming. There's no objection that she should never use that. There's no motion eliminated made at that time. But no, I don't know of any real grooming cases specific. I do know in Chattahsong, I get those confused, Simmons and Chattahsong, whichever one was found harmless, the comments made were more similar to that case than they were to the one where I think it was Simmons that was reversed.
That's correct.
Yes, thank you. That the prosecutor in that case used the veneerman to basically establish the Stockholm Syndrome. We don't have that here. There's no, besides the prosecutor using the word grooming, there's no evidence to basically overemphasize that word any more than you would use it in saying, I'm grooming such and such for office.
Well, I guess I'm troubled when you say they must have found each of these witnesses credible, when that's a large part of the prosecutorial misconduct issue is her very clear vouching for the witness's credibility, very specific vouching.
I don't think that she did specific or clear vouching that was inappropriate here. She based it all on the evidence, and this court has said as long as it's based on the evidence, that's fine. I mean, yes, she said, yes, they're credible statements like that, but it was always couched in, and here's the evidence that backs that up. And if we're not, I mean, this court has said when it's credibility competition or credibility contest of some kind, that you're allowed to make comments on credibility as long as you couch it in the term of evidence. You're just not allowed to have personal opinions.
I'm going to quote.
Okay.
Each of these girls with their own take on it, with their own point of view, so no embellishment. Yes, they are credible. They are not tainted, or they have not been poisoned by the suggestibility that the expert is trying to get you to buy. That's not an expression of opinion?
And there's another, the next, she's referring to another witness, and she says, Jay is a motor mouth, vomit of information. And she says, how many times, he talked about how many times he was pinching her nipples and where and when. Yes, that's credible. And the same he's credible comment with the next. And she's pretty specific.
She is specific, but I do think it's bookended generally by, and I can see how it could arguably be construed as comments on credibility, but it is bookended by evidence. Even in the quote that you just read, she's talking about the evidence there. And the one Justice Beyer read is more troubling to me. But I don't know.
Speaking of book ending.
Reason to say, and one of the comments basically was attacking, as I understand it, the defense expert as trying to influence what the children were saying. Was that right?
Well, the defense expert, I think, testified that
finding words is suggesting.
Yes, finding words is unduly suggestive, and
my point is that was also in the same trial where the prosecutor basically dismissed the finding words protocol by saying, well, here's a case that basically says you should not be paying attention to that, and we're done.
And I know I talked about in my brief the fact that there were two experts and both said that you should try and get to the truth and discuss suggestibility, etc. And I see what you're saying, that when she's attacking the expert and has basically had unsworn testimony that this finding words is indeed valid, but her expert also testified to that. So it wasn't, if there was no evidence to support finding words as being a solid interview technique.
She's just trying to put her thumb on the scale on the way out of her questioning of this witness. I mean, that's what that comment says to me. I'm volunteering this, nobody can challenge it, and I'm just putting my thumb on the scale a little bit to add more credibility. In what is a credibility fight, counsel volunteered misinformation to try to tip the balance of the determination on credibility. I mean, am I reading this wrong?
I don't have a great explanation. She never should have said that. Do I think she was trying to unfairly influence the trial? No, I don't.
What if you add in what I started to say about the book ending? In her opening statement, she basically introduces the complaining witnesses as credible by saying these children have grown in the last year. The mother handles the children with calm competence or something like that. I mean, isn't that basically an endorsement that what this mother's going to tell you is credible, what these children are telling you at this point is credible?
If she'd put in any evidence to support that, opening statement rarely is a big issue in prosecutor misconduct because we don't know what evidence will be produced.
But it is pretty clear that at any point in the trial, a prosecutor should not be expressing their personal opinions about credibility, and that I don't know how else you read those statements.
I don't know how else to read those statements.
Or character. I mean, really, because we all know that opening statement is supposed to be a preview of the evidence as you expect it to come in. There are limitations on your prescience, as we all know, not argument.
It's very clear that the theme throughout her entire argument and everything she did was that the kids are credible. Because this was a credibility contest, I can't contest that at all.
What about moving past the outcome determinative test that you kind of dwell on? At what point do we have so much prosecutorial misconduct that we just say, this defendant did not receive a fair trial?
At the point in which it affects the evidence.
It's only an outcome determinative test?
There's no outer limit. There's no outer limit where we should just say, you know, there was a lot of evidence that this trial was not fair.
I mean, that's what you do in cumulative error, so I can't. I think generally the ill will, gross, and flagrant, that is why that's in there, is to say that even if it wasn't necessarily affecting the outcome, it went too far, and you say that. And that's why those particular portions of the test exist. I don't think that occurred in this case.
Can I direct you to another issue?
I was going to circle back to the recitation of the judicial opinion by the prosecutor. As I recall, our case law has warned our trial judges to be very careful about how they act and what they say in a jury trial, because even a raised eyebrow or a quizzical expression or some sort of a comment the jury is listening to or watching to see what the judge thinks about a particular piece of evidence or something that's at issue in the case. And I'm just wondering if we have something even more than that here, when a prosecutor basically is saying a group of judges have said, and she cites, is it Mooneyham case? A group of judges, not necessarily the judge who's here, but a group of learned judges.
I don't know.
Well, isn't that the implication?
She says court. I'm not sure that the average juror would understand that that means an appellate court that has a group rather than just one person. I don't know that it matters one way or the other, but I don't know that that would be a juror's inference. Also... Well, to reduce that, though, there's been a reference that some judge who's important enough, I guess, to have his or her opinion published has made this ruling. So isn't the implication, whatever may be going on in this courtroom, some judge has made this ruling, and we're kind of done with that issue? And it goes to the credibility, which I think you've indicated was kind of the large issue that ran throughout this trial. I don't know how much that would have affected a juror. I think if it would really have affected a jury, the defense counsel would have moved for a mistrial right then and there. They didn't. The jury, there would have been an objection or a move to strike, a motion to disregard, anything to keep that out, if that is how damaging that statement would have been. I think basically everyone defense counsel anyway, hoped that everyone ignored that, and they never focused on it again. It wasn't pointed out. It wasn't emphasized in any way, shape, or form. During her closing argument, she didn't say that finding words was the gold standard. She discussed the different expert testimony. It was one statement in a very long trial. I just don't think it would have had the impact that we can sit here with hindsight and look at.
Well, the jury looks to the judge to rule on evidentiary issues and looks to the judge to issue their jury instructions, which are basically the statements of law. And now they're being told by a prosecutor that here's a judicial ruling. So why would that not have a lot of impact on a jury?
I'm not sure. It's not this judge. You're also told to use the law as it applies in this case. You're not supposed to use anything outside of this case. That these are your instructions. The instructions are the entirety, and nothing in the instruction says, because another court said because the prosecutor says another court says finding words is the gold standard, that's what you're supposed to accept. Nothing in the instruction said that. The instruction said use of this.
The objection to the question was overruled.
And the objection to the question was overruled.
Okay. Are there more questions of prosecutorial misconduct? Okay. I'd like you to address the aggravated indecent solicitation unanimity issue.
Okay.
I think that one, there was no objection. I don't think it looks like there's anything in the record that constitutes a specific election by the state on that particular charge.
Is this count 16 then? She elected on every count. Count 16 was the only one that was slightly confusing as her election, but
I think that's one we're talking about. Aggravated indecent solicitation as to L.
Okay.
Okay? That's the one I'm trying to focus in on.
16.
Yeah, it was count 16, wasn't it? Okay, yeah.
Okay.
You're in the right place. I don't usually think of them in numbers, so sorry. So explain to me how that's not clear error.
The failure to give the multiple acts instruction. Well,
yes.
Generally, if there is a unified defense, and there was one here, clearly they believe the credibility of the victims. So he didn't contest that this act didn't meet it. He was just saying he didn't do it, so that any error in failing to give a
And that's not the only test, is it? It also matters whether the victim's testimony shows any variation from incident to incident, right? Isn't that one of the other things we look at? And this did
yes.
not, right? She just said it happened several times, the asking her to show her chest.
Yeah, frequently asking to see her chest and get mad if she not wanted to do so eventually.
Okay.
And then she lifted up her pajama top to let him see her chest. That was count 16. I don't know that she was ever inconsistent. It was just that it happened multiple times, and so they had to either agree that yes, it did happen multiple times, or pick one time.
Okay, thank you.
I guess I'm out of time, so I won't reach the other issue.
Any further questions of counsel?
I just want to clarify, when you're talking about witness credibility, did the jury convict on any of the counts on which the boy testified?
No.
Okay, so apparently they at least found one of the witnesses totally incredible.
Apparently, yes, or...
Okay.
So thus...
Or didn't think whatever he testified to measured up to the charges.
Right, could also be.
I'd like to hear what you do have to say on the exclusion of the evidence issue, just briefly, if you might, because I know your opponent's going to address it on his rebuttal. It seems only fair to give you a minute or so.
Thank you. The evidentiary rule doesn't allow it. It's a specific incident of conduct. The Kansas Court of Appeals has crafted an exception, which I don't know that should even exist. But the rules do not allow it. The United States Supreme Court has made clear that just because the fundamental fairness does not necessarily require you to bend your evidentiary rules for the defendant. In cases where it has been bent by other courts, it doesn't mean that they allow it for basically a mini trial within a trial. They don't allow the evidence that basically the defense wanted in here, which was to parade multiple family members into the court and say, well, she said that there were some unspecified allegations because I've never seen the details of these allegations. Instead, they would have just been able to ask, did this allegation ever happen, yes or no? It's clear that the victim and her mother both would have said the allegation never happened, and that would have ended it. So there couldn't have been any error. But I think you should actually just apply the rules of evidence. Specific evidence of conduct don't come in, and it never should have come in.
Any further questions? Thank you, counsel.
Thank you.
May it please the court, the defendant had 4 witnesses who would have testified that M had previously said that her biological father molested her, but later admitted it was a false statement. The court excluded those witnesses and cross-examination on those points because the court said, well, the only witnesses are family members and there's no independent evidence as to from third parties like law enforcement officers. That was an abuse of discretion. Whether or not these were family members was clearly a question for prosecutor cross-examination on motive, bias, and interest.
So the abuse of discretion was a failure to apply the correct legal standard.
I'm sorry, Your Honor?
The abuse of discretion you're alleging was the failure to apply the correct legal standard?
Yes, in that regard, and that it also denied him his Sixth Amendment right to confront the witnesses against him. The evidence was clearly admissible in order to confront the primary witness in the case with the fact that she had previously falsely accused parental authorities to get her way.
What about the statute?
any citation to either Nevada versus Jackson or KSA 6422D on specific instances is, I think, handled completely by the ruling implicit in the Magallanes case and the ruling explicit in the Court of Appeals decision some 14 years ago in State versus Barber, where it recognized under certain circumstances the limitations of KSA 6422 must bend to the defendant's right of cross-examination. I think that handles the specific instances issue as well as the Magallanes opinion. As to Justice Biles' question about harmful error, I want to point out that, as the prosecutor conceded, this was a credibility contest. Remember, the defense pointed out shortcomings in the interviewing techniques, and Mike Akins testified that in court that either these touchings never occurred or that they were never done with a sexual intent. As Your Honor noted earlier, they found they didn't believe Ethan. They could have found that they didn't believe M if the evidence had been introduced impeaching her and if the prosecutorial misconduct had not occurred. It was a close case. The dynamite of unsworn prosecutor testimony, as was raised in Simmons, can cause a guilty verdict that otherwise could be not guilty. We've given prosecutors the atomic bomb of Jessica's Law life sentencing, and I know this court expects prosecutors to handle that conscientiously and carefully. One way to remind them to do this is by reversing the convictions based on the misconduct here of a veteran prosecutor. This prosecutor at sentencing touted that she had been prosecuting cases for 20 years.
I have a little problem. I understand you're arguing send a message to prosecutors, but we have a disciplinary administrator for that purpose, and why would we put victims through the trauma of a new trial to show the prosecutor the error of her ways?
I think
you understand what I'm asking?
I do, but I'm not saying that we reverse only on that basis. I say we reverse because this meets all of the standards of TOSH for prosecutorial misconduct. And certainly the court can feel comfortable with finding that and reversing this case because of the life sentence power we give prosecutors with Jessica's Law. For all of the reasons stated today and in our brief, I would most respectfully ask this court to reverse the convictions in this case and remand the case for a new trial. Thank you very much, Your Honors.
Counsel, before you sit down, I did have a question going back to the Barber decision that you referenced.
Yes.
And I can't remember exactly how you characterized what they did to 6422D, but I think it's fair to say, is it not, that what they did is not found in the clear language of the statute?
I agree with that, Your Honor. What they found was that the Sixth Amendment constitutional right to confront witnesses trumps the impediment of 6422D, and I think that's also implicit in Justice Byers' decision in the Magallanes case when she says the redacted portion of the letter would have rebutted both JP's statement implying she was a virgin when she first had sex with Magallanes and impeached her testimony overall. Prior accusations of false sexual abuse is something essential to the theory of a defense in a sex case where that's the articulated defense. If 6422 really is a specific instance, then it has to be trumped by the Sixth Amendment right to confront the witnesses. And I think that's what a number of decisions from the United States Supreme Court say, in effect, Davis versus Alaska, for that matter, and it's clearly what the Barber Court and I think Magallanes says.
This is not unique to this case. Evidence of false accusations by victims are at least offered as testimony or suggested it could be testimony in all kinds of cases, but especially in these types of cases with indecent liberties or rape. How was this brought before the court? Was this just in the middle of cross-examination of M? Was this a pre-trial kind of proceeding? How did this occur?
Yeah, that's a good question, and Your Honor may want to examine the lobbying that this prosecutor did from the very beginning.
I'm not talking about that. Just answer my question as to how this came before the court, this particular question of the false accusation. Did it come during trial?
No,
Was this the first?
it came from the pretrial motions and was litigated again and again and again. I believe in our brief we make kind of a chart of all of the times that was raised and what the result was. So it wasn't something that just came up in the middle of trial.
Thank you.
I'd like to go back to the discussion about Barber.
Yes.
I think you've admitted what that court did is not contained in the plain language of that statute. And this court, at least in recent years, has tried to say, if you got plain and unambiguous language in the statute, that's what it means. So my question is, by what authority is the Court of Appeals grafting something on to that statute? Do you have any opinion on that?
I guess I'd say two things. I'm not sure that the instance of a witness lying about a similar accusation such as is on trial is just a specific instance of a character trait tending to show it's bad. Some courts would say, I think it's Kansas courts, I think State versus Beans would say, no, this is admitted not as a specific instance, but to show that the witness is lying under oath at this trial. Because if confronted, isn't it true that you lied about sexual abuse occurring from your biological father-in-law? And they've already said she's going to deny that. We've got 4 witnesses to impeach her on that. So I'm not conceding that it is a specific instance.
Did she lie under oath at a prior proceeding?
No.
About this? That's just what you said.
Well, what I meant was, had there not been the in limine ruling of the court, the defense attorney could have cross-examined M about that at this trial, and if she denied that, impeached her. And in that instance, I think it wouldn't be a specific instance. I think it would be the impeachment permitted by the Sixth Amendment right of confrontation of the Constitution. And I think
Speculate as to whether she's going to lie at this proceeding.
I'm sorry, Your Honor?
Nothing.
I don't want you to think I assumed that. The prosecutor said she's going to deny that she ever said that. But, again, do we have to take the prosecutor's word for that, or was the defense entitled to confront the witness with that on the witness stand under oath at trial? So I don't think the Court of Appeals was legislating. I think they were following the United States Supreme Court decisions that hold that in instances like that, state statutory protections are trumped by the Sixth Amendment.
Well, even the Barber decision by the Court of Appeals doesn't indicate that, in this case, a defendant is able to make this allegation, say, here are my 4 witnesses, therefore let's go to trial on the issue. They say that these are admissible only after the trial court has made a threshold determination that a reasonable probability of falsity exists. Isn't that kind of what the judge did here?
No. There was no question that these were false statements because the prosecutor represented that, in fact, the witness would say she never made them because she was never molested. That brings in the necessity for the 4 witnesses. Yes, she did say she was molested, and now she's saying she never said that. So there was no contest about whether the witness was going to say that any allegation of molestation by her father was false. So the Barber threshold was not even contested here, and admission of the evidence was necessary to confront the witness under the Sixth Amendment.
Are you able to address the U.S. Supreme Court's decision earlier this year in Nevada v. Jackson, and how that might affect your argument?
I don't think my argument is any different about Nevada versus Jackson than is it about Barber. I mean, and again, there's a different standard there because it was a 2255 proceeding. But there, I think they said that if a trial court finds that extrinsic evidence is unduly prejudicial or a waste of time and that sort of thing, they can make that determination and we're not going to disturb it. But I don't see it as being in the same posture in Nevada versus Johnson as the right of confrontation was in Barber or as it would be here. I think they were just saying the court has the right to do that under its state rules. I don't think it was in near the same situation as we have here. Thank you, Your Honor.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honors.
Thank you both for your arguments this morning. The court will take this matter under advisement.